Gregg Jarrett, Fox News legal analyst, and Will Scharf, Trump attorney and former federal prosecutor. Gentlemen, great to see you. Thank you for being here. Greg, big question in everybody's mind, will this decision, because it sends it back to a lower court, so you got the more back and forth going on, will it delay Jack Smith's trial until after the election?
I think it's quite possible that it will, because it goes back to the trial court, and Tanya Chutkan, who is the trial court judge, has to hold evidentiary hearings. That may involve witnesses, perhaps. And if Trump doesn't get what he wants, he will file, I'm quite sure, an immediate appeal. And if that's granted, then you're talking about litigation that could stretch into weeks, maybe even months. But there are a couple of things that I think a lot of people are overlooking. First of all, this is a presumptive protection for the president for official acts, which shifts the burden of proof to a guy like Jack Smith, and that's a high burden. And second of all, they said the trial court cannot look into the motives of the president. That's forbidden by the separation of powers. And so, you know, all of this, you put it together, and it makes it look much harder for Jack Smith to pursue his case against Donald Trump.
Well, as usual, I think Greg hit the heart of the issue, which is the motives issue that Jack Smith didn't have. He knew he was going to have trouble if he had to get into it. The Supreme Court says now you can't get into it. Let me just read what they said about the motive issue. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Such a highly intrusive inquiry would risk exposing even the most obvious instances of official conduct through judicial examination on the mere allegation of improper purpose. That really takes a quiver out of Jack Smith's collection of arrows, doesn't it?
It does. And the court's general ruling that the prosecution can't use immune acts or evidence of immune acts, even to prove intent with respect to non-immune acts, taken all together, all of these aspects of this opinion strike a fatal blow at the heart of Jack Smith's D.C. prosecution. I mean, what we're looking at here is a very broad immunity doctrine that, when applied to the facts in this case, I believe make this case essentially untriable. We have many months of litigation ahead of us on the immune versus non-immune distinction. That could easily, as Greg said, result in further appeals, including potentially all the way up to the Supreme Court. But I think the immediate takeaway is that this D.C. prosecution is on life support. It may even be in hospice care.
But Greg is saying, just sticking with you for a second, Will, Greg is saying that there is still a chance. You got to be careful with regard to Jack Smith's, his determination to get it done before the election is obvious, because it's such a political case anyway. You say it's close to zero chance of a trial before the election?
Yes, and in fact, when you look at the majority opinion authored by Chief Justice Roberts, he has some very strong statements about how the courts have rushed this case at every stage, and he clearly disapproves of the fact that this case has proceeded on a political timeline and not a normal legal timeline. So again, I think taking every aspect of this opinion together, looking at the immunity doctrine that the Supreme Court has created, it will be essentially impossible for this case to move to trial before the election day, if it ever gets to trial at all. I think this has dealt, again, a near fatal blow to the D.C. prosecution, and this case also may have ramifications in Florida and New York as well.
Well, we'll talk about that in a moment. But, Greg, I want to pull back and look at why this immunity issue is so important, because they really talked about that. I mean, you as a constitutional scholar, I'm sure we're interested in this part, and I'm going to read it out again. An enterprising prosecutor, and I was thinking of Jack Smith when they wrote this, an enterprising prosecutor in a new administration may assert that a previous president violated a broad statute. Without immunity, such types of prosecutions of ex-presidents could quickly become routine. The enfeebling of our presidency and government that would result from such a cycle of fractional strife is exactly what the framers intended to avoid. To which you say what?
Well said. All presidents have unique responsibilities under the Constitution that demand independence to function effectively. And regardless of their party, David, they must be protected from bad faith prosecutions driven by political animus, which is exactly what special counsel Jack Smith has done. Understand, this isn't blanket immunity. It's what I would call conditional, albeit presumptive, protection for official acts, not private acts. And as I predicted, the court adopted the exact same standard enunciated in Nixon versus Fitzgerald 4 decades ago that shields presidents from civil liability. The same reasoning applies to criminal culpability as well. Otherwise, it would have a severe chilling effect on presidents.
Yeah. And again, looking at the overall issue here, and I think you wanted to get into this a little bit, Will, the idea of the politicalization or the weaponization of our legal system. Lawfare is the catchphrase for that. I mean, what we see here, I think, is what really scared the Supreme Court, particularly with regard to the intentions of the people who developed our Constitution. They did not want lawfare. They did not want the politicalization of our legal system. They wanted to leave those things separate. But that's exactly what all these cases, not just the Jack Smith cases, but all these cases really tend to do, no?
I think that's exactly right. And, Justice Gorsuch perhaps said it best at oral argument when he said that this case isn't really about President Trump. It's a case for the ages. What kind of republic does our Constitution set out? How is the separation of powers going to operate in the future? And today, the Supreme Court drew a very firm line under the idea that these sorts of political prosecutions, the endless cycle of recrimination and prosecution that Jack Smith's efforts here and Joe Biden's efforts here may have opened, the Supreme Court slammed that door shut and said that with respect to former presidents, immunity protects them from prosecution for their official conduct, that the grant of immunity is broad and deep, and that we need to shut this sort of thing down before it absolutely destroys the institution of the presidency.
And Greg, it's not just about the president. The former president is always saying it's not just about me. First it's me, and then it's going to be you.
Right.
And the Fisher case, which was decided on Friday, was so important. The case of Mr. Fisher, by the way, is a former cop who was there on January 6th, and he was charged with obstruction in kind of a bank shot legal play that the Supreme Court knocked down on Friday. I'm just wondering, that's, first of all, it's not just good for Mr. Fisher, it's good for a lot of other people that were charged with that, including the president, because 2 of the charges that Jack Smith had could be affected by that, right?
Yes. The ruling in Fisher on Friday essentially guts half of the case that Jack Smith brought against Donald Trump. I mean, he misused, quite typically for him, an obstruction statute that has no application. But look at his remaining alleged crimes. Fraud. Well, wait a minute. That fraud statute deals with money and property. That has no application. Then you're left with just one charge, violation of voting rights. But wait a minute. You're allowed to challenge the electoral count in Congress by law. Democrats did it in 3 previous elections. In 2017, they tried to remove Donald Trump in favor of Hillary Clinton. Somehow, when Democrats do it, oh, that's perfectly okay. When Donald Trump does it, it's a crime. That's nonsense.
Well, let me move you quickly. I'm getting a wrap, but I have to talk about July 11th, the sentencing date for Donald Trump by Judge Merchan in New York. You look at what happened with the debate last week, and you look at the politicalization of the courtroom under Judge Merchan with that particular case. I'm just wondering if one affects the other. Do you think that as the judge is getting ready to sentence Donald Trump, he may take the politics we saw inside the courtroom during the trial to the sentencing as well and try to throw Donald Trump in jail 4 days before the GOP convention?
Yeah, I think Judge Merchan is irretrievably conflicted here. He should have been recused off of the case. I won't hazard to predict what he's going to do at sentencing, but whatever he does at sentencing, we are going to be vigorously challenging that judgment on appeal. It's also worth noting that we've raised claims of presidential immunity in that New York case. We believe that some of the acts that were raised at trial, some of the evidence introduced there, do relate to official acts. So the jury's still out in some respects. I think we are going to be continuing to challenge that aspect of the New York prosecution, and that may very well be a ground that could get the U.S. Supreme Court involved in overturning the jury verdict in that New York prosecution.
And Greg, very quickly to you, brother, on this whole subject of the politicalization of our legal system and whether or not that's going to affect the actual sentencing itself, particularly because of their fears that Biden did so badly in the debate.
Well, it should, but it won't. And let me just say this. What the dissenters in today's decision don't seem to realize is this ruling protects Joe Biden and future Democrat presidents from the same kind of lawfare that Biden Democrats deployed against Donald Trump. They just don't get it.
All right, Greg, Will, great to see you both. Thank you so much for being here. Appreciate it.